Пане Романе, доброго дня.
Good afternoon, Roman. Good afternoon.
Трошки затримується сигнал.
I think that we are having a delay with the signal.
Ага, ніби все нормально.
It appears that it's okay now.
Пане Романе, вітаємо вас на другому
Good afternoon, Roman. Welcome to stage 2 of the selection for HQCJ members, the interview stage. Your interview will be conducted by all members of the commission. Let me introduce them. Sergey Verlanov, Ivan Mishchenko, Steven Markman, Yevhen Mezentsev, Teza Zhechny, and Robert Brugeisen. The rapporteurs for your interview
є Сергій
are
Верланов.
Sergey Verlanov and Steven Markman.
Якщо з якихось причин
Should for any reason
бесіда буде перерва,
our interview be interrupted, we will definitely reach you
того моменту, на якому вона
and
була перервана,
we will resume the interview from the point where it stopped. We will reschedule it on a different day.
під час співбесіди прохання відповідати.
We are kindly asking you to be very brief and precise when answering our questions, but before we start with the questions, we will give you the floor to tell you a little bit more about your motivation and ideas. With this, I am passing the floor to my colleagues. Sergey, Steven, you're welcome.
Пане Роману, розпочну нашу співбесіду.
Dear Roman, let me start our interview with a short biographical introduction.
Kydysiuk Roman Анатолійович.
So this is the interview of Roman Kydysiuk, who was born on the 25th of January of 1979. He has a degree in law. He started his career as a legal counsel. Then he worked at the Constitutional Court of Ukraine as senior consultant, senior research consultant to a judge between 2011 and 2012. He was the advisor of the chair of HQCJ, and since July 2012 and up until now, he is a judge of Lviv Oblast Commercial Court.
Має загальний стаж галузі
The total experience of work in the field of law is more than 21 years, and more than 10 years of experience working as a judge. The candidate has provided us with a certificate of his fluency in the official language.
пропоную вам на протязі 5 хвилин
Roman, you will now be given the floor. You will have up to 5 minutes to tell us about your motivation as to why you have decided to participate in this competition. You're welcome. Thank you. Good afternoon once again. It appears that you have already introduced me a little bit, so I will not be reiterating the same information. So I would like to tell you that since the moment that I've become a lawyer, it has been my desire to become a judge in the future. And when I already got acquainted with the procedural aspects of the work of a judge, when I studied the relevant codes, the legislation on the status of judges, I realized that a judge can restore justice. And this is something that motivated me to study law and to become a judge. Then, when I already started working, I came across this very interesting statement, which became further realization for me. So I was charmed by this statement, this quotation. I don't want to discriminate against any religions in my opening statement, but I don't want to be talking about the priority of any religion. But the quotation I'm going to refer to, I do believe that these ideas are present in the majority of religions existing in the world. And let me provide you with a specific example. So, administer justice and you will save people from those who are mistreating and oppressing them. It's not just about the judges and courts. It's also about the people who behave in the right way, who are not aggressive, who don't discriminate. But in the contemporary world, there should be a body that needs to restore justice in the society. And in the context of this statement, of this idea, we also should be talking about integrity. My key message is that if the society, in civil society in particular, which is becoming strong and stronger in Ukraine, if civil society demands a fair court, a court with integrity, then it means that members of HQCJ are entrusted with this noble duty of complying with the high status of integrity. That's if to be brief. Thank you, Roman. So let us proceed to the second part of our interview, and that is the questions. So my first question is as follows. According to the information from your tax declaration for 2015, you indicated that you own a parking space with the area of 21.6 square meters, which you acquired in June of 2007, and also a land plot with the area of 1,000 square meters, which you acquired in February of 2002. Why am I pointing out to the date of acquisition of these assets? Because the information about this real estate was not mentioned by you in your declaration for the year 2014. The question is, why did you not declare this property in your declaration of 2014? The thing is that the state registration of ownership to this real estate happened much later than the year 2014. So the fact that I indicated the date of acquisition prior to 2015, maybe that was my mistake. So could you please clarify, why did you not declare that in 2014? Well, because the state registration of ownership to these real estate objects was registered after 2015, which means that these assets were declared later. So you officially declared these assets in 2015 after state registration of your ownership rights, right? Yes, I started declaring them starting from the year 2015. And you can see information about state registration in the extracts that I have provided to the members of the Commission, and you can check the dates when specifically I acquired ownership rights. Thank you. My next question, why is it that in your declaration for the year 2015 you did not indicate the value of the land plot with the area of 1,000 square meters? Could you please explain that to us? I have no idea what the value of this land plot is, because, how should I put it? Because according to the State Act, I acquired it free of charge, right? Under the procedure of free of charge privatization. Okay, thank you. Your answer is clear. My next question. According to the information from your declaration for the year 2017, you mentioned owning 13 investment certificates with the value of 1,300 hryvnias, which you acquired in December of 2011. Could you please tell us why did you not mention the information about these certificates in your declaration for the year 2014? Well, with regards to these certificates, I indeed made a mistake. Because at the time when we already had a new system of declaring assets via NACP, the system did not have access to the registry of investment certificates and securities in general. But at the same time, I do recognize that this was my mistake when I was buying those certificates for a price of 1,300 hryvnias. That's the price of 13 certificates. I forgot to declare them by mistake. But I can confirm the price of these certificates, and it doesn't mean that I am trying to hide something. After I have discovered my mistake in the upcoming declaration, I did declare those certificates, and that was something that was discussed by HQCJ during my qualification assessment, and I provided detailed explanation. And there were no further questions asked from me. Thank you. So my next question. Answering question number 8 of your motivational letter, you said that, in your opinion, in order to enhance trust in the judiciary, should you be appointed as a member of HQCJ, we need to ensure that court judgments are enforced by executive authorities, because non-enforcement of court judgments tarnishes the authority of courts. So, could you please explain how can a member of HQCJ influence enforcement of court judgments by the executive service, for instance? Well, an HQCJ member cannot do that, but because of the high status of HQCJ within the judiciary, a member of HQCJ can initiate some procedure in order to solve this issue on the legislative level. In what way? At the same time, should there be a series of questions about changes necessary for HQCJ and the judiciary, I can explain that in more detail. But this is my answer with regards to this question. Well, I'm not asking you about any novelties or amendments, but the question is, should you be appointed as an HQCJ member? In what way are you going to be influencing the enforcement of court decisions by the bodies of executive service? Well, can I add something to my answer? Yes, please. So I had another suggestion there while answering this question about changing of the gradation in the assessment. So can you please answer my previous question? How are you going to influence the enforcement of court judgments? But anyway, in your motivational letter, you also mentioned that in order to improve the selection and the qualification assessment, we need to change the methodology for the assessment of candidate judges and judges. We need to expand on the indicators of integrity. So what indicators of integrity should be included into this expanded list? Well, We know that the assessment takes place under three main criteria: professional competence, professional ethics, and integrity. So let me explain why in this general scheme of things I would like to develop more indicators of integrity. What I'm suggesting is that the weight of integrity be enhanced, that the component of integrity becomes more important. I believe it to be more important than all the other components, even though the other things are also important. But if we are talking about the proportion, integrity should be given more weight. Also, I have an idea about distribution of the criteria of integrity, breaking it down into two components. One of them being mathematical, where we have clear-cut criteria for which commissioners can give scores. So let's say financial aspects, then, for example, I'm giving you examples. I'm not ready to give you a specific list, but the fact of any positive and negative information about the candidate available in mass media. So any indicators that can be calculating using some mathematical formula. So this is one part of integrity that should be assessed, and the second part should be the closed part. And this means that it's up for the discretion of an HQCJ member to vote for a specific candidate as far as their integrity is concerned. There are some things that cannot be measured using any mathematical formula. That is why I would suggest for 10 to 15% of this subjective, but in a positive sense, subjective voting, which would reflect the inner conviction of an HQCJ member. This is their discretion. Because not everything, if we are talking about integrity, can be measured. So that is why I would leave 10 to 15% for the discretion of HQCJ members in assessing the integrity. So 10 to 15% for the subjective opinion. I understand. So you are suggesting to break down the criteria of integrity into the mathematical component and non-mathematical component, or subjective component, yes. So the mathematical component should be scored, and the non-mathematical or subjective should be assessed at the discretion of an HQCJ member without any scores. So this is the novelty that you are suggesting, the amendment to the methodology for the assessing of candidate judges and incumbent judges. Thank you. Your position is clear. I have no more questions for you. With this, I'm passing the floor to Judge Markman. Stephen, you're welcome.
Thank you, Judge. And thank you, Judge Kydysiuk, for participating in this competition and being here this afternoon. You profess that the Ukrainian citizens are seeking to pursue the fundamental values of a democratic society, such as integrity, justice, and zero tolerance for corruption. These are your values, too. Is that a correct understanding? You share these values, and if you were elevated to the High Qualifications Commission, you would be working in pursuit of these values?
Yes.
Now, you've got a very impressive historical perspective on the High Qualifications Commission, don't you?
Ну, як історичне? Ну, я за нею спостерігав, а в першій
Yes, yes.
каденції
Well, I was watching the activities of HQCJ and I was part of the staff of HQCJ, so that's where my perspective comes from.
Okay. Let me take you back to 2011 or 2012 when you were working with the High Qualifications Commission. If somebody had asked you at that time what the commission and what the state of the judiciary in Ukraine would be, say, around January 2023, how might you have viewed it at that time? And do you tend to be impressed with the development since that time or perhaps disappointed since that time? What's your historical perspective of what's happened over the course of the past 11 or 12 years in your country?
абсолютно. Ну, по-перше, це характерна риса кожної людини.
Well,
Завжди на краще. І
it's the trait of every person to hope for the best and to expect that better things will happen in the future.
стосовно доброчесності.
But let me tell you about integrity.
Можливо, попередники чи
I'm not trying to say that the previous HQCJ or its members or the judiciary of the past was worse than it is now. But the demand of the civil society, as far as the development and progress is concerned, always raises the bar.
і не виключено, що через 10 років
And maybe in some 10 years, the bar
набагато більших
will be
набагато більших вимог.
will be even higher.
Це нормально.
And it's normal, it's natural.
Категорійне поняття доброчесності
And this idea of integrity, we cannot measure it because it's a dynamic process.
в 11-му році ніхто не
For instance, in 2011,
інституту доброчесності в
the Institute of Integrity was not prescribed by law. There were some other concepts similar to integrity.
описані
They were maybe not described in detail, but there were similar values present.
як це доброчесність
And
зараз міняється
we can see how
історичних умов.
interpretation of integrity changes based on specific historic circumstances. For instance, a year ago, nobody would have thought that as part of integrity assessment, we would consider absence of collaboration with the aggressor state. And I do believe that this is a fundamental thing.
Певні категорії,
That is why I don't think we can limit
які ми включаємо в
the categories that are to be included into integrity. Integrity is a dynamic process.
But you think the bar that you're describing has at least been moving in the right direction since you served on the commission. Is that right? Things are going in the right direction, but maybe not with as much speed as we would all like. Is that a fair statement?
абсолютно так.
Yes, absolutely. We are moving in the right direction.
Я, наприклад,
Okay, well, give me a sense, Judge, of what would be your first priority if you were appointed to the commission? What would you seek to be doing on the first day? How would you bring to bear your historical perspective and your support for changing the High Qualifications Commission? What would be the thing you would be discussing most excitedly with your new colleagues?
Отже, перше, оскільки всі усвідомлюють,
Well, since we all realize
система потребує нових кадрів
the degree to which the judiciary needs new staff because we have lots of vacancies to fill. I will not be inventing the wheel here because previous candidates have already mentioned this. I think that the priority should be to fill in the vacancies and to complete the transfer of judges to appellate courts. Why am I telling you about this? Because at the same time, we can launch the procedure for the selection of candidate judges, excluding those who have not yet completed their qualification assessment. So we can initiate the selection so that in parallel we can do the transfers of judges to appellate courts so that the candidates have an idea about the number of vacancies that are out there. And as far as the novelties are concerned, I can tell you about this in more detail. There is this one thing that I'm most concerned about, and I think about this life hack. So if you'd like me to continue, I will tell you about it.
Please do, briefly.
I'm talking about the appointment of people who have the new candidates who are going to be appointed. So in the previous HQCJ, we had this issue that many people on the rating list who had low scores were not appointed as judges because the list was relatively closed. Nobody knew where the other candidates applied, to which court. And the second HQCJ, the second iteration of HQCJ, partially solved this issue. They gave the opportunity to the first, second, third, and fourth dozen of people to alternate between different courts depending on the rating that was formed. So some of them applied to administrative courts, the others applied to some local courts or provincial courts. And it gave people an opportunity to even be appointed. Because it appeared then that the people completed their qualification assessment, you were scored, but there's no vacancy that you can fill. That is why I would suggest that the candidates can apply to at least 5 courts. I understand that there are 400 candidates that may apply to 5 different courts, and that's a lot. But if we have this rating list with the scores, we will use the computers. We can use a specific algorithm and software, and the computer in 2 minutes will decide how to distribute between these vacancies. I'm not talking about some random distribution. I'm talking about simplification of the decisions for the commission. So
you want more flexibility on that. You want more flexibility in terms of filling positions. Is that fair to say? Okay. Now let me ask you. You were on the editorial board of the Journal of the High Qualification Commission. Is that still published?
Yes, this journal is still being published, but I'm not on the editorial board anymore.
No, I understand that. But let's say they have a feature every month on one commissioner of the High Qualifications Commission, introducing the reader to one member of the commission. And then when the member leaves the commission, they put together a short summation of his legacy on the commission. What would you like the legacy of Judge Kydysiuk to be on the commission? When your term and time on the commission is done and the publication you once served on the board of editors writes about your work and your contribution to the commission, what is your legacy in short?
Well, I think that other people have to assess me, not myself.
Of course they do. That's what I'm asking. What would you like them to say about you, though?
Well, probably let them tell about the innovations that have been implemented. I'm not talking about any possible things, likely things, but the innovations that have been introduced and have helped to reduce the load of on the system to improve the judiciary by selecting adequate judges.
So you're determined to introduce innovations, and you hope that'll be one of the things that the publication says upon your departure from the commission. Am I understanding you correctly?
Well, I think that the innovations can be judged only after they implemented. So actually, yes, but innovations depend not only on me, but on the whole collegial joint body and on how relevant the innovation is. But if it is a joint body, you will have to judge on the basis of the results of decisions of the whole commission.
Well, you're resisting a very easy question from me. I'm trying to put a very simple question to you, and I'm not getting a clear answer. What would you like your legacy to be on the commission? I know you won't be writing it, but you know the publication, and I'm describing something that will be written about you. Would you like them to say that innovations are your legacy? Would you like them to say that you've changed the methodology in significant ways? Would you like them to say that you've been a great recruiter for the judiciary of Ukraine? I'm still trying to understand what is important to you, and maybe what's not important to you at the same time.
Well, for me, actually, in a way, everything is important. And this journal is not just about the results of performance. This journal could also be about some academic things, academic findings that are not only related to the work of the commission, and that would be a kind of an embellishment for the journal as well.
Okay, thank you, Judge. Appreciate it. Mr. Broekhuizen?
It's me again. Okay. Yes, Judge. You are in the commercial court of Kiev. Lviv, sorry. I'm wrong, huh? Lviv. Yes, Lviv. I'm sorry. Can you tell me what kind of a disputes is you're handling on a day-by-day basis at present and just before the war? What the disputes, commercial disputes are they? Just in short.
Well, before the war and now as well, we are considering such disputes as imposition of charges, corporate cases, recognition of ownership. And in our court, we have two panels of judges about bankruptcy, but this panel considers only bankruptcy cases, and the other panel that considers all the other cases. So everything that is subject to the jurisdiction of commercial courts is considered by the panel, is heard by the panel I belong to, but for bankruptcy cases.
Okay, very good. So that means that the cases that you hear may have, let's say, quite an extensive interest for the parties that appear before you.
Yes.
Yeah. Do you have sometimes cases that involve oligarchs?
Не було.
I haven't had any. The only thing I remember
Одна справа,
is one case
де боржник
where the debtor
під санкціями
was under the effect of some sanctions. He was the
казав, ну ми під
well, his representative said, legal representative said that they were under sanctions, but under the law there are no restrictions anyway. So the case has been completed. Court granted the motion and charged
грошові кошти
some money from the debtor in spite of the fact that he was under sanctions, because the law does not prohibit us from doing this.
Okay. Are there international disputes or are there mainly national disputes? Are there, let's say, international parties involved?
дуже рідко.
Well,
Я
on a very rare basis,
після завершення військових дій
we may have some foreign parties. I hope that after the end of the hostilities and after the investment climate is back, after it is restored, we will have more of such disputes.
закону про міжнародне
Under the law, international private law, sometimes we have debtors in the territories of other countries, and there is an agreement
про юрисдикцію України,
which says that disputes will have to be considered within the jurisdiction of Ukraine.
зазначивши окремо саме такий орган. Інколи таке
And
буває.
so sometimes it may happen, but these are very rare cases. We have much more agreements saying that the dispute will be within the Anglo-Saxon system of law jurisdiction.
На жаль,
Because unfortunately,
так є
so far it is the case that this system is trusted much more.
і англійським судам.
Yeah, that's exactly what I'm pointing at, because I find it, of course, strange that there are no international disputes before a commercial court in Lviv. I'm just asking myself why they don't come to your court. And you write in your motivation letter that you hope this will get better after you've been appointed in the HQCJ. But you're in this court for quite some time. Why are those international parties not coming to your court for a decision?
Ну, по-перше,
Well,
інвестиційний клімат
investment climate of Ukraine is not the best climate ever,
по-друге,
at least now.
можливо,
That's why they do not
те саме. Я
come to my court.
я неправильно
Maybe I've provided the wrong explanation, but I didn't mean international disputes. I meant when there is one participant, trial participant, staying in Germany. I mean, there are two elements. One in Ukraine, one of them is in Germany, and the agreement says that the dispute will be considered, will be resolved in the jurisdiction of Ukraine. So in case this is indicated in their agreement, then disputes could be considered by our court. That would be the grounds for the case consideration by our court.
судах, місцевих
But that's very rarely the case.
я думаю,
And I think that
з часом
with time,
ця крига скресне.
the situation will change, and business entities, including the ones with a foreign element, will trust our courts, Ukrainian courts, more.
Судам України.
But do I understand you correctly that
Можливо, зараз розкажу про причини.
I could tell you about the reasons, if you're interested in that.
Дуже всеукраїнська ситуація
There was some situation, high-profile case
законом про режим
with the law on the regime of foreign investment. And I think that this law actually led to the deterioration in the level of trust in Ukraine as a guarantor of fair trial and fair dispute resolution. That is the reason. If you're interested in that, I could tell about this.
No, what I'm interested to know from you is whether you think that the fact that there are no, let's say, international disputes in your commercial court has anything to do with the court itself, or whether, in your view, it is that the court itself is performing perfectly, so the fact that there are no international disputes is not related to the performance of the court.
This is not related to the bad performance of our court. This is just the general picture, which unfortunately we are facing in the judiciary, in the Ukrainian judiciary. That's it.
But you still say that you are someone who wants to change the judiciary for the future. If there is no problem, why would you change?
Well, let me repeat or probably rephrase my ideas. There is always room for perfection, in particular as far as the category of integrity is concerned. From year to year, the pressure of the civil society and some circumstances allow us to raise this bar of integrity. And this should be reflected on the activity of the state authorities, in particular the activity of judges and courts.
Yeah, but I think that you understand my question. What I have read is that there is not sufficient trust of many people in the courts of Ukraine, and that also the European Union believes that, let's say, that in any case the integrity of the courts of Ukraine should be increased, and that changes should be made in the way courts and judges behave and act, and that's one of the reasons there was introduced the vetting of candidates, the fact that there are foreign specialists, etc., etc. And now we are busy to choose, let's say, new candidates for the HQCJ. And the point is that I have, for myself, and maybe you understand that, difficulty to select someone who believes that no changes are necessary because the courts work perfectly. That's the reason I asked you the questions about your own court. And you say, well, my court is perfect court, nothing is wrong. But please appoint me in the HQCJ because I will make things better. And that I don't find logical.
Well, I didn't mean that my court is an ideal court. But, you know, let me use some Ukrainian saying to illustrate the situation, that one sheep can actually spoil the whole herd. And the importance of this one sheep is sometimes really great. I mean, that if there is some negative fact, that will tarnish the reputation of a lot, and that is a major problem. So in order to avoid such situations in the future, I mean, actually starting with now, we should work at the development of the crystal clean rules and reputation. If the members of the HQCJ are people of integrity, I think that the court and the judiciary will also change because it will get new people of integrity. We have people of different ages in the judiciary, but anyway, within our dynamic picture, we see things evolving, we see things developing. Nobody says that everything is ideal. Of course not. But we somehow need to move on. And we shouldn't be sad about this. We just should do something about that.
No, I agree that you should do, and I don't want to have a discussion about you because it's not my position to be in a discussion with you at all. And of course, I have also insufficient knowledge of the position. But for people who say that they are agents of change, to be someone who indeed affects change, the first thing you need is the belief that something needs to be changed. And I didn't hear that, but I understand now that indeed some changes needs to be made in the judiciary, also in Lviv.
Ну, тоді я плавно переходжу до, напевно, те, що саме змінить.
So let me go over to the changes. What exactly is necessary to be changed in the judiciary? We were talking about the Institute of Decision Enforcement, and in my motivation letter, I mentioned that one of the changes is to exercise court control, to allow court control decision enforcement better, because decision enforcement is actually the final stage of the court proceedings. It should somehow be controlled by court.
We have read, of course, your motivation letter. We have seen that. Maybe I pass the floor to my colleague, Mr. Zajecny.
Thank you. Mr. Kydysiuk, I will follow up a bit on the theme that my colleague, Mr. Broekhuizen, discussed with you, and that is the theme of your motivation document, which deals with the introduction of innovations in the work of the HQCJ. Assuming that if the HQCJ, as we hope is the case, will be appointed and re-begin its operations, one of the important partners of the process of judicial analysis and vetting is the involvement of the Public Integrity Council. And I think you will be aware that there have been some difficulties in the relationship between the Public Integrity Council and the High Qualification Commission of Judges. What do you see as the role of the Public Integrity Council? And my second question or follow-up question is, if you consider that the role of the Public Integrity Council should become more important in the work of the HQCJ, what would you recommend for changes that might bring that about?
Дякую.
Thank you for the question. Well, definitely the role of the Public Integrity Council is important. It's a fundamental role, I would say. And I have not yet voiced some of my proposals, but one of them is that the role of Public Integrity Council should also be valid for judicial candidates. I mean, not only for qualification assessment, but for judicial candidates in general. They should have some role to play there in the qualification assessment and judicial selection in general. Also, if we speak about Public Integrity of Council, just some joke. Do not crack jokes on that point. Be careful. As far as Public Integrity Council is concerned, you shouldn't have any jokes. Well, it's not a joke, but just saying in humor. You know that wolves are the sanitaries of the woods, and they are helping us. I don't think that it's a bad joke. It's probably a little bit ironic, this statement, but I think that it's what their role is. They have to help us, and the role is to help us. So I think that the increase in the role of the Public Integrity Council is something we will definitely face. And we know that recently the anti-corruption strategy has been approved by the High Council of Justice, and this anti-corruption strategy suggests overcoming the negative opinion of the Public Integrity Council by more than a half of the members of the HQCJ and the Public Integrity Council.
така новація.
So this is the innovation which is not yet supported by the law, but I see that efforts are made to increase the role of Public Integrity Council, and I actually support this. I think that
Роздолання висновків відбувається
if now we have the situation that that we have to overcome such negative opinions, and 2/3 of the members of the HQCJ have to vote to kind of reject this opinion. But my personal opinion would be that probably the threshold should be increased by 3/4 for us to be able to find this balance between the Public Integrity Council and the HQCJ. But the role is increasing. And this is done for civil society to be absolutely confident of the fact that dynamic and positive changes are taking place.
All right, and I know that you explained the opinion of others, like the High Council of Justice, but what is your opinion? Do you support an increased plurality, if I can use that term, of voting to overcome the recommendation of the PIC?
Я підтримую
I do support the importance of and the increased importance of the Public Integrity Council. And probably, unlike the anti-corruption strategy, which presupposes 50% plus one vote on both sides, I mean, both from the PIC and HQCJ, I think that probably this will reduce the sovereignty of the Commission a little bit, because still it is the Commission that is responsible for this process. So I think that probably it shouldn't be 50% plus one vote, but it would be a good compromise if this negative opinion of the Public Integrity Council could be rejected not by 2/3, but by 3/4.
це теж є збільшення впливу
This would also mean the increase of the role of Public Integrity Council and its impact on the development of the judicial staff.
Thank you. Let me turn to another subject as part of the innovation strategy, if I can call it that, for the HQCJ. I have the impression in the past that the work of the HQCJ and the communication with the public was primarily through the chairman of the HQCJ and to some extent the secretary of the HQCJ. We've heard about the judge speakers that the members of the court elect as a spokesperson for particular courts. I'm wondering whether or not, as an innovation, you would support the idea of the HQCJ electing an HQCJ spokesperson who could take some initiative for outreach to the public, establishing public forums, for example, where members of the HQCJ could meet with members of the public, discuss not individual candidates, but generally the work, what is being done by the HQCJ at any particular point in time, etc. We would call that a public outreach strategy. And I'm wondering what you think about that kind of an idea. Do you think that would be a good innovation to introduce?
I think that it's a good innovation. Sometimes, even if you are absolutely right, but if you keep silent, if you are tacit, In some members of civil society, of the public, or their organizations may have some grounded or ungrounded doubts. That's why communication, public outreach are extremely important in this respect. But the only thing is that we should think over the format. I mean, how this should be done. It should also be done via Facebook and regular meetings, as you have mentioned. I think that this would be very much welcomed.
Thank you. I will pass the chair over to my colleague, Judge Mizentchev, to ask questions of you as well.
Thank you, Justice. Пане Романе, доброго дня. Моє прізвище Мезенцев.
Good afternoon, Roman. I'm Yevhen Mezentsev, and let me continue communicating with you at this interview. It's a pleasure to see that we have a candidate who used to be a delegate of the Congress, who is the lecturer of the National School of Judges. It's good that talented people participate in our competition, and all the more that if they are judges. But here is the question. I'm a judge who used to work in the system of commercial courts, taking care of the issues of intellectual property like you do. And of course, I feel a little bit nostalgic about the period of time. But I would like to ask you the question concerning protection of intellectual property. You will probably agree that this category of disputes is not the most difficult among all the dispute categories heard by commercial courts in Ukraine, because the overwhelming majority of those disputes are accompanied by the opinions of court experts, where a lot is said, and we just have to assess the work done by this court expert. There is a concept laid down in the law on the establishment of the High Intellectual Property Court. And at the final stage of the establishment of this court, we had some failure because of the non-operation of the HQCJ. What about the future? Do you think that it's worth establishing such a specialized trial court? And what are the advantages and disadvantages for the availability of this specialized high court at first instance? Clear. So let me start with some statistical data related to the number of cases our court has. First of all, unfortunately, taking into account economic relationship in Ukraine, so far, that is really not the lion's share of our disputes, of our cases. I mean, cases related to intellectual property rights. Yes, I know this. That's why I'm asking you, will this court have enough cases, or will they have 4 cases to consider a year? I think that as a specialized court, probably the High Intellectual Property Court could still exist. This would be a court considering only intellectual property cases, and in a way, this will provide for the quality of the decisions passed. But do you think that the quality is not good now? Do you have a lot of your decisions cancelled? No, the quality is due, it's adequate, but if a commercial court considers different types of cases, and the Court of Intellectual Property will consider only one type of cases, it will be more professional anyway in this respect. And, you know, our Constitution has the provision on the establishment of specialized courts. It's not indicated what courts are meant exactly, but I think that when our relationship related to intellectual property that gets better developed in Ukraine, there will be a need for the establishment of other specialized courts, so why not? I remember our talk with the president of the Land Court of Bavaria. They have construction courts, they have some other types of courts, so you don't need to be afraid of this specialization. When the economic relationship starts developing, I think that our commercial courts can be overloaded, and specialized courts may have a role to play here. That depends on the development of the relationship in the market.
майнового плану.
Here are some property issues. While studying your documents, including the declaration, we paid attention to the fact that your mother gave you a power of attorney in 2020
На користування банківським
for the
сейфом.
use of the bank safe.
Тривалість довіреності
The
5 років.
duration was 5 years of this power of attorney. Could you explain the reasons for issuance of such power of attorney, which is a civil act?
Ну, задля чого?
Why?
Можливості відкрити власну банківську ячейку?
Is it not possible for you to open your own bank safe? How did it happen? Why did it happen?
Так. Справа в тім, що я коли
The point is that when I got acquainted with my file, I saw that there was a question you have just voiced. Maybe I provided the explanations when I was sending this document, but yes, but we have to explain it to the public. You know, you have to provide the explanations, oral explanations. Yes. Let me explain this. So, my mother and my father sold their car in 2020. And you can see this confirmed by the registries, sales registries. And there was an agreement between the purchase-sale agreement parties that the sales would be in cash. So for security reasons, my mother and my father gave me the power of attorney because they wanted someone else to have access to this bank safe besides them. And I'm the only son in the family, and that's the reason for that. Did you declare the use of this bank safe cell in your declaration or no? No, I didn't, because I didn't use it. Okay, clear. But there was an agreement like that. You mean that you physically did not open it, right? Yes, I did not open it. And by the way, to declare something, or rather, we put it in a different way. If you're using something, you need to declare, but I didn't use it just because I didn't use it and because it was never opened. It was never created by my mother, because in October of that year, the money was spent on the purchase of another apartment. So actually, this power of attorney was pointless. No, back then it was relevant, but of course, you're right. Okay, clear. Again, as far as your professional activity is concerned, there have been several claims made, and they have been all rejected by the competent bodies exercising control over the judiciary. And one of those claims actually drew our attention because of the subject, the entities. That was the claim submitted by the Consulate General of the Republic of Poland in Lviv. Could you explain the details? How did it happen that a foreign entity actually made a claim, made a complaint concerning your activity? Well, yes. This happened in 2018 or 2019, if I'm not mistaken. And I remember that the legal service of the Republic of Poland passed the concept to give complaints against all the judges considering one case. That was, well, actually, that was a cascade of several cases that were related to enforcement, to performance of contractor works. These were constructions works related to the building of the premises of the consulate in Lviv. And I don't know any single judge in the commercial court of Lviv region who wouldn't have had to deal with this case. So the case was migrating from court to court. It was also brought to our court, and they actually complained about everyone who had to deal with this case. So you also got this red card from the consulate. Yes, kind of that. And it is rather ironic because my father knows the consulate general of that period. That is Yaroslav. And still, it is okay that they submitted this complaint. Okay, anyway, the complaint has been rejected. Just I needed to clarify what the problem was. Thank you. And let me ask you one following thing concerning your political
приналежності,
adherence or belonging.
оскільки в розпорядженні нашої комісії є дані про те, що
Our commission has got the data that rather long ago, you used to be an assistant of Oleg Ternebok, their deputy, when he was representing the party Our Ukraine. This was rather long ago during the first calling of the Verkhovna Rada. Could you now explain what your political views are and whether you have any relationship with Oleg Ternebok now? Well, my political views are manifested only in voting during the election and referendum. I don't have any adherence to any political parties or views. As far as Oleg is concerned, I don't have any further relationship with him. Back then, it was as follows. Oleg was responsible for some issues in Western Ukraine, and my father had some contacts with him over a certain period of time. We got acquainted, and I presented to him my book. That was some collection of papers done in co-authorship with other colleagues from the Constitutional Court. We had some talk with him, and he just suggested that if he is interested in some legal issues, he would address me, and that's the way it happened. This was happening for some 2 years, and after that, after those legal consultations, no further relationship was maintained. Thank you, clear. Let me give the floor to the chairperson of the commission, Ivan.
Thank you.
Пане Роман,
So, dear Roman,
як ви ставитесь до судового активізму?
what's your attitude towards activism in the judiciary?
Так.
Activism in the judiciary. Okay, so let me explain what I mean by this. It's when the court decides that the norm of law is unconstitutional and does not apply it, so the court creates their own law, let's say. That the attitude is positive. In addition to adhering to legislation, we also need to use the principles of the rule of law. I think it's most important for administrative courts. I have a colleague of mine, my classmate, and we've had this discussion with him. It appears that quite often when there is a case in the administrative court and there is a question about recognizing some of the provisions as unlawful or unjust, it's more relevant for them. But in my practice, I've had 2 situations like that when I did not recognize, something as unlawful, but I motivated my refusal to apply the specific norm of law, but it wasn't even a law, it was a bylaw. But when making my decision, I had to motivate why I refrained from using that specific provision. I explained which provisions I applied. Yes, I understand, but the question is whether you follow the principles of law in your work. So, for instance, the principles of impartiality, prohibition of contradictory behavior, when the norm of the law says something which is quite on the opposite. When there is an agreement of rent not signed,
але декілька років виконується, і потім орендодавець вирішує.
and for many years this agreement is fulfilled, and then the person who rented something like an apartment, they go to court and they want to recognize this agreement as null and void. Well, we need to have a closer look at things like that, because if two parties did something in order to enforce this agreement, then I would recognize it as being effective, because there were some legal consequences stemming from that agreement. Thank you. And I have a follow-up question. Courts use judiciary activism in situations when there is no norm of law, or the norm is formulated in an ambiguous way, or the norm is formulated in such a way when its application will result in an unjust decision.
Ми всі досить часто використовуємо поняття
Quite
доброчесність.
often we use this notion of integrity, practically all the time.
Однак, поняття доброчесність ніяк не
But the
визначено.
notion of integrity is never defined in the legislation.
І можуть існувати різні погляди на
And
те,
there
що є
may be
доброчесність, а
different
що
interpretations
доброчесність не
of
є.
what integrity
Як ви,
is.
як, професійний суддя, який
So
може
you, as
опинитися
a
в
professional judge that may be appointed to HQCJ, how do you suggest that we solve this issue when we have different interpretations as to whether specific behavior has integrity or lacks it, and there is no definition in the law?
Так, ну, частково я повернуся і до свого до своєї відповіді.
So let me come back to my previous answer.
Новій вищій кваліфікаційній комісії.
So, as a potential member of HQCJ, I would suggest that assessment of integrity
Тому, власне, і закладалося
that is not always measurable. That is why I was telling you about the 10 to 15% of the assessment being part of discretion of every member. So the subjective assessment of the behavior and demeanor of the candidate.
Тому, власне, я ділив цю доброчесність.
That's why, as I've already told you, there are two categories or two components. The first component, the one that is mathematically measurable, and the second one,
Переконанням, яка
something that is subjectively assessed.
де дала нарадчий.
Так от я
As we
вас і
do
питаю про це внутрішнє переконання. Оскільки якщо
according to
можна
our
звернутися
discretion
до
as judges, but I'm asking you about the discretion. So if there is no source to confirm this or that fact, the discretion may differ, because there may be different assessments of one and the same behavior. Somebody may say that this is behavior of integrity, while others may contradict this.
Це голосування, це якраз симбіоз.
That is why I'm saying that the decisions made by HQCJ
Разом вони проголосують,
is the sum total of their opinions, the opinions of all the 16 members.
Зрозуміла ваша позиція.
Well,
Скажіть,
thank
будь
you.
ласка, я вправ-
для когось це, наприклад,
Ну, я
я перепрошую,
вашу
для
відповідь.
когось
I'm sorry.
це має-
Кажіть.
Okay, you may proceed.
Я мав на увазі, що для когось
What I meant is that for one person it may be important, while for somebody else it may not be of importance. And what we are trying to do is to have some uniformity in our opinions, so that the collegial body works to its full capacity. And it's important that all the members of the commission have a similar idea of what integrity is. Do I understand it correctly that should you be appointed as an HQCJ member, you are planning to be using the integrity criteria very actively, and you are planning to assess the availability of integrity very profoundly? Do you understand it correctly? Yes. Yes. I believe that the integrity review should be done on the basis of documents arriving from different sources. Yes, that's clear. But why do we need the PIC then? What for?
так ГРДН ключову роль
The PIC plays
займає
the key role in this process at the moment. That's why we need PIC. So it's an alternative opinion that can be provided from somebody else other than the Commission members. So we can get some additional information that the Commission doesn't have in its possession. So it's like the scales. On the one side, we have the PIC. We have the positive characteristics, and the HQCJ is on the other side of the scales. But practically, that's the function of the HQCJ, to determine whether the candidate has integrity or not. Do I understand it correctly? Yes. The Commission already forms its own opinion. And we have the PIC, which is forming an alternative opinion. Do I understand you correctly? There will be two opinions on integrity? No. When I said alternative information or opinion, I meant that if we are talking a candidate judge or an incumbent judge, when they are submitting their documents, they want to show their best sides. And what the PIC is doing is they are looking for information that maybe does not characterize that person from the best side. So the very essence of the work of HQCJ is to assess this information provided by them. Yes, I understand that, but it's the functional duty of the Commission to also look for positive and negative information and to assess it. In cases when the Commission failed to find something or the PIC has some additional information, that's clear. But don't you think that it's a crossover, it's an overlapping of the same functions? You are forming your own opinion about integrity, and the PIC does the same. They also form their opinion. Doesn't it appear that the same job is done twice? No, it's not being done twice. It's being reinforced. Okay, thank you. I understood you. And should your opinions differ, what do you do then? So I've already told you that. So there was this practice of HQCJ to have unmotivated opinions. We should leave that behind because the civil society should know what the justification for specific decisions was. But if there is motivated explanation to our decisions, if there are some facts, then definitely it's positive. But in order for us to make the decision, in order for HQCJ to make the decision, I suggest that we not only make use of the pragmatism, I also suggest that we increase the plurality of votes. Don't you think that PIC emerged because the state, according to the society, was not performing its functions in the right way? It was not checking negative information, or was turning a blind eye to it, or maybe was overlooking this information. And the dissatisfaction with this fact resulted in the setup of PIC and a whole range of civil society organizations which advocate for the principles of the rule of law, integrity checks, etc. And let's assume, I hope, that they were successful in that, and the state has started performing these functions. The state has started checking integrity and doing it in a systemic and efficient way on a day-to-day basis.
у такій ситуації
In a situation like
все ж таки,
this,
в чому буде полягати оце підсилення? Як ви
what
бачите
is going
оцю
to
спільну
be
роботу
the
з
role of
громадською
PIC? Where does the reinforcement
на
lie?
такий базовий рівень спустимося?
Because
Ну, якби буде два висновки.
if we go down to this basic level, there will be two opinions, their opinion and your opinion. If they are the same, then fine. If not, then 3/4 of votes to overcome the negative opinion. What I meant that maybe 3/4 in case of a negative opinion should. This is something that should already be red flag for HQCJ.
Не помиляється.
And you think that the PIC is never wrong, right?
Я ж вам кажу, для того є
That's why I'm telling you, for this very purpose,
голосів, яка долає або
we have this ability to overcome negative opinions.
комісії це перевіряє.
Now it's 2/3 of votes. I suggest that it's 3/4 of votes. But as far as civil society control is concerned, back in the day when our civil society was much weaker, I didn't really understand how it was supposed to look like, but
Є багато
the way it is right now, when we have many civil society organizations being watchdogs, when we have mass media
і за суддями, то
watching the activities of courts and other government authorities, I think it's proof that there is some positive dynamics in the civil society. Thank you, thank you. I understood your position. Do we have any other questions for the candidates? Yes, if I may.
Нерідко з нашими кандидатами дискутуємо
Roman,
з приводу
on many occasions,
запобігання корупційним
we
проявам
discuss
судової влади.
prevention of corruption in judiciary with our candidates. It's not a new topic. I think this tale is thousands of years old, so we are all trying to think how to prevent judges from taking bribes.
Задокументованих способів
And
боротьби,
one of the
зокрема,
first recorded ways to stop this was mentioned by Herodotus, and there was this Persian ruler
нечесного суддю
who had a corrupt judge. His name was Sison.
з пана судді зідрали
And
живцем.
in the end, the judge was skinned, and belts were made from his skin.
Наступником цього судді був його власний син.
And the person succeeding that judge was his son.
Сина Сісамна.
And when Sison's son was appointed as a judge, he told him, "You should never forget that your father's skin was used to make not only belts but a throne on which I'm putting you." So this is quite an extravagant but maybe efficient way to prevent corruption.
Зрозуміло, що в нас в цей
In the
раз,
judiciary.
в наші демократичні часи ці засоби
Well,
не
I
є
hope
застосовані.
that in a democratic society, measures like this will not be used, but
Висіла
the
у
painting
судовій залі
with
ратуші,
canvases
міста Брюгге у 15-му та 16-му
trial could be found on the walls in one of the courthouses in the city of Bruges. So in the 15th and 16th centuries. So would you consider it expedient in order to prevent corruption among judges to maybe have portraits of convicted judges in courtrooms, or maybe having discussions of corrupt judges amongst other judges, or perhaps any other ideas or instruments that you can think of which could help us prevent corruption in the judiciary? You're welcome.
Я думаю, що кожен службовець,
I think that every official, every civil servant or judge are fully aware of how they should behave and what type of behavior, what mode of behavior they're choosing for themselves. Having some paintings on the walls Well, maybe it's possible, maybe for somebody it will work, but maybe not. For me, a quotation from the Bible is much stronger than that painting.
Я думаю, десь так паралельно.
Yes, something like that. That is why I'm asking you. We need to work out a mechanism to prevent corruption and not just interrupt corrupt actions. Corruption should be made not beneficial. We should have zero tolerance for corruption within the judiciary. That's why we are inviting you to discuss it with us. Please express your opinions. So, I don't think a painting is going to be convincing enough for most people. But what I can see in dynamics is that we are moving in the right direction. Well, first of all, the civil society has no tolerance for corruption. And secondly, again, everybody is very much against it. And also the salary of judges and officials is increased so that they don't even have any ideas about corruption. Thank you. Do we have any other questions?
Що ви хотіли доповнити, будь ласка?
Did you want to add something?
Пане Романе, що ви хотіли доповнити?
Я маю на увазі в умовах сучасності застосувати
Under contemporary situation, we cannot apply those rules from the situation that you have described to us. I don't think it will be efficient.
Будь ласка, у когось будуть ще запитання?
Thank you for the answer. Do we have any additional questions for the candidate? There are none.
Пане Романе, на завершення нашої співбесіди
So, in conclusion of today's interview,
на протязі 2 хвилин
you're given the floor for 2 minutes to summarize your ideas, and suppose you'd like to add some information or clarify something, you have the opportunity to do it now.
Я хотів подякувати.
First of all, I would like to thank you.
Навіть перекладачам,
I would like to thank the interpreters, the supporting staff, everybody helping in organizing of this selection. I would like to express my sincere gratitude to the commissioners.
ставила і ставить питання,
Thank you for
які є
asking questions
важливі, актуальні.
that are relevant for the society.
Тим самим ви робите тон,
By doing this, you set the direction,
ціннісні орієнтири для того,
you set the values so that the future members of HQCJ
як задає
set the bar really high in the same way as you have set it for yourselves.
особисто переконаний і дякую, що вже
I'm personally convinced that those 64 candidates who have been admitted to stage 2 are worthy to be appointed as members of HQCJ. That's why I wish all the other participants good luck. Thank you.
Дякуємо вам, пане
Thanks
Романе.
to you.
На цьому співбесіда завершена.
This is the end of your interview. Thank you for participation. Good luck to you and take care. Goodbye.
дякую.
Thank you. Goodbye.